Good morning, everyone. It's 9 o'clock. We'll go ahead and get the Planning Commission meeting started this morning. Welcome to the July 27th, 2020 Planning Commission meeting. Recommendations from the Planning Commission on certain items from this agenda will be considered by the Board of Commissioners at their regular meeting on August 4th, 2020 at 10:30 a.m. The Planning Commission utilizes speaker request forms, which are available in the Commission chambers during the meeting. So the speaker request form looks like this. If you have an item on the agenda that you are neither the applicant nor the agent for the applicant and you wish to speak on that item, we would ask that you fill one of these out and then you can just bring it to me here up at the dais. Helps keep me organized during the meeting and has a process for who speaks when and those types of things. With that, we'll go ahead and start roll call, noting that Jim is on Zoom, so we'll have roll call votes today instead of everyone responding at once. It looks like everyone is here with Ron from the board. First item on the agenda is the approval of the July 13th, 2020 minutes. Are there any corrections or changes to those minutes from anyone on the board?
Mr. Chairman,
Go ahead,
I
Sam.
just noticed on item number 21 and 22, it says the vote was 6-0, whereas everything else was 5-0. So I couldn't recall if somebody else had joined the meeting. It was on 21 and 22. It's not a big deal, but
So there was only 5 of us, right? Because
Yeah.
Charlie and Jim were both gone.
yeah, all the others were 5-0.
No, that's a good catch.
You know.
I think that those
Make a
would,
correction.
what's that?
We'll correct
Correction
that.
to the minutes for items 21 and 22 to change from 6-0 to 5-0. Are there any other changes? Seeing none, I would entertain a motion for approval of the minutes, noting those changes on 21 and 22.
I so move.
Second.
Motion and second. Is there further discussion? Seeing none, roll call vote.
Rich,
Aye.
Ron,
Aye.
Jim,
Aye.
Travis,
Aye.
Kathy. Aye. Charlie,
Aye.
Sandy.
Aye.
Motion carries. Next item on the agenda is approval of today's agenda. We have items 3 through 11 on the consent agenda, regular agenda items 12 through 19, and our follow-up 4 items at the bottom there that are normally on our agenda. Are there any changes to the agenda for today? Seeing none, hearing none, I would entertain a motion for approval.
Move approval.
Second.
Motion and second, further discussion. Seeing none, hearing none, roll call vote.
Rich,
Aye.
Ron,
Aye.
Jim,
Aye.
Travis,
Aye.
Kathy. Aye. Charlie,
Aye.
Sandy.
Aye.
Motion carries. Brings us to today's consent agenda.
Good morning, Commissioners. Brittany Molitor, Planning Director. The following items have been placed on the consent agenda for action to be taken on all items in accordance with staff's recommendation by a single vote. Any item may be removed from the consent agenda by any planning commissioner, staff member, or audience member for separate consideration. The findings of this planning commission are recommendations to the Pennington County Board of Commissioners, who will make the final decision. Item number 3 is Conditional Use Permit Review CU 1612, TC Enterprises, Inc., Todd Schultze as the agent, to review the use of bicycle rentals, ATV rentals, and retail shop as a neighborhood commercial in a suburban residential district. And staff is recommending approval of the extension of Conditional Use Permit CU 1612 with conditions. Item number 4 is Conditional Use Permit Review CU 1821 for David and Leah Byers to review a single-family residence in a highway service district. And staff is recommending approval of the extension of Conditional Use Permit CU 1821 with conditions. Item number 5 is Conditional Use Permit Review CU 1824 for Plainsview Mobile Manor, Ernest Shannon, Christine Forrest as the agent to review an existing mobile home park in a suburban residential district. And staff recommends approval of the extension of conditional use permit CU 1824 with conditions. Item number 6 is conditional use permit review CU 1837 for Glenn and Debbie Lepp to review a store and fiber mill in a general agriculture district. Staff recommends approval of the extension of conditional use permit CU 1837 with conditions. Item number 7 is conditional use permit review CU 1916 for Terry and Marcia Graber to review an existing residence to be used as a bed and breakfast recreational area in a general agriculture district. Staff recommends to end conditional use permit CU 1916 with the applicant's concurrence. Item number 8 is conditional use permit review CU 1917 for Adam and Elrod Lacey to review an existing residence to be used as a vacation home rental in a limited agriculture district. And staff recommends to end conditional use permit 1917 as it is no longer needed. Item number 9 is Plan Unit Development Review PU 0607 for Rapid City MHP LLC Cimarron Mobile Home Park to review a plan unit development to allow a mobile home park. Staff recommends approval of the extension of Plan Unit Development Review PU 0607 with conditions. Item number 10 is Major Plan Unit Development Amendment Review PU 1502 for Deerfield Park condominiums to review an existing plan unit development in accordance with Section 508 of the Pennington County Zoning Ordinance. And staff recommends approval of the extension of Major Plan Unit Development Amendment Review PU 1502 with conditions. And finally, item 11 is Major Plan Unit Development Amendment PU 1903 for Prairie Valley Development. Bill Freytag is the agent to amend an existing plan unit development to allow for additional lots to be developed. Staff recommends approval of the extension of Major Plan Unit Development Amendment Review PU 1903 with conditions.
Thank you. Are there any items that staff wishes to pull from the consent agenda?
Yes, item 10.
Okay. Are there any items that the board wishes to pull from the agenda? I would pull number 6 for a minor clarification. Okay. Are there any items that the audience wishes to pull from the consent agenda? So for those of you that may be new to this process and new to this meeting, items 3 through 11, with the exception of item number 6 and item number 10, will all be approved with one vote on the board. And so if you wish to speak to one of those items, I would that we would need to pull that from the consent agenda. Seeing none, today's consent agenda will be items 3 through 5, 7 through 9, and item 11. Is there a motion?
I move for approval.
Second.
Motion and second. Is there further discussion? Seeing none, hearing none. Roll call vote.
Rich,
Aye.
Ron,
Aye.
Jim,
Aye.
Travis,
Aye.
Kathy, Charlie,
Aye.
Sandy.
Aye.
Motion carries. On item number 6, I just noticed that in the staff report, so not in the agenda, but in the report itself, on page 1 of 6, it says staff will be recommending to continue continue this item to the July 27th, 2020 Planning Commission meeting. But then at the end of that section, the end of the section recommendation matches what's in the agenda. So indeed, the idea here is that you guys are recommending approval of the extension of the conditional use permit and not to continue, correct? All right, so I would just note that correction and would entertain a motion for approval.
I'll move approval.
Second.
Motion and second. Further discussion? Hearing none, seeing none. Roll call vote.
Rich,
Aye.
Ron,
Aye.
Jim,
Aye.
Travis,
Aye.
Kathy,
Aye.
Charlie,
Aye.
Sandy.
Aye.
Motion carries. Brings us to item 10.
Good morning, Commissioners. Christina Proetti. I wanted to pull item number 10. I did have a typo on page 1 of 7 and then again on page 5 of 7. On current zoning, on page 1 of 7, it says general agriculture district. That is incorrect. It is planned unit development. And then again, page 5 of 7, section 3, existing conditions, letter A. Again, that should say planned unit development and not general agriculture district.
I'm sorry, what page were you on?
Page 1 of 7, and then again on page 5 of 7.
Thank you.
Any further questions on this item? Seeing none, hearing none, I would entertain a motion on item number 10. Recommendation from staff is for approval, noting the changes to the staff report from general agricultural to PUD.
I move for approval.
Second.
Motion and second, further discussion?
Chairman,
Go ahead.
just as a curiosity, so on page 5 of 7, section Roman numeral 3B, and then it gives the acres legal non-conforming lots. So I can see when I was reading general ag, I thought, well, it needs to be 40 acres. It makes sense, but is it really legal non-conforming?
That,
As a
I'm glad you
PUD?
caught that too. I just caught this morning, I'm sorry. That is actually a typo as well. It is 4.7 acres.
40.7?
4.7
Oh, 4.7.
for planned unit development.
Okay. Very good.
Sorry about that.
Yeah.
So is that's a correction then to item B as well?
Correct. 4.7 acres is what it should be.
Right here.
Are there any other locations in the report that discuss those same acreages or those corrections? I'm not
I
seeing any.
believe, other than that, it does look good. It was the zoning that carried over and then the zoning acreage from, I believe, something else.
Okay. So noting those two changes, we had a motion and a second for approval. Is there further discussion? Seeing none, roll call vote.
Rich,
Aye.
Ron,
Aye.
Jim,
Aye.
Travis,
Aye.
Kathy,
Aye.
Charlie,
Aye.
Sandy.
Aye.
Motion carries. Item 12.
Morning, Commissioners. Jason Thennison, County Planner. Agenda item 12 is Layout Plan 20-17. Applicant is Jeffrey Jamison. He is in the audience if you have any questions for him. The applicant has applied for Layout Plan 20-17 to combine 4 existing lots in order to create Lot 15R of Oak Meadows Estates. You can see up on the screen, on the left are the existing lots, and on the right are the proposed lots. Existing conditions as the lots sit today, they all take access off of Oak Meadows Court. There is no special flood hazard on any of the properties. They are zoned limited agriculture district, and specifically Lot 15 is 3.5 acres, contains a 24 by 24 foot guest house with attached garage and a 10 by 13 shed. Lot 16 consists of 3.6 acres and a 14 by 27 foot horse stall that does not have a permit on file with the Planning and Zoning Office. Lot 17 is 3.5 acres, has a single-family residence, and no county operating permit on file with the Planning Department. And finally, Lot 18 is 4.64 acres and is vacant of any structures. The proposed lots on the right, they'll all just become one lot. And access will continue to be off Oak Meadows Court, and there's no special flood hazard area on the property. Will consist of 15.24 acres and continue to be zoned as limited agriculture district. The request was sent out for interdepartmental review. County environmental planner noted that there was no operating permit for lot 17 for that single family residence. The reason for this is that there was no address assigned to the guest house on lot 15, and it has its own operating permit and septic system as well. So the lines kind of got crossed there. So we only have one operating permit for both of these properties, and that's something I'm working with the applicant now to straighten out. Also, like I said, there was no address assigned to that guest house at the time when it was built or permitted. So I've assigned an address to that. I'm working with the applicant to get that squared away as well. Staff's analysis of the request is that the proposed lot will meet the minimum size requirement for a limited agriculture district. Like I said, the address will need to be posted in accordance with ordinance number 20, and the applicant will need to obtain a county operating permit for the single-family residence on lot 17. Additionally, an approved building permit will need to be obtained for the 14 by 27 horse stall on lot 16, and an approved conditional use permit will be required for the guest house on lot 15. Once these are all taken care of, staff finds no significant issues with the applicant's request, as it appears to be in harmony with existing lots and current land uses in the area. And with that, staff recommends approval of layout plan 20-17 with conditions.
Thank you. Are there any questions? Go ahead, Sandy.
I just have one question. What is the purpose of combining it all into one lot? To get the addresses straight, or?
I'll bring the applicant up and he can speak to that.
Go ahead and come up, sir, and then state your name for the record when you get to the mic.
Jeffrey Jameson.
I just wanted to know, what is the purpose of combining it all into one lot? I mean, it seems to be functioning in the 4 separate lots, but,
It's more personal than anything. I had a living trust done,
oh,
and so I
okay.
have four children, and so I didn't want them to get into a dispute over who was going to get which lot.
Ah,
So I thought I'd just combine it all together.
that makes sense. All right.
Further-
Thank you.
Further questions? Seeing none, staff recommends approval of layout plan LPL 20-17 with the 10 conditions listed. Is there a motion?
Move to approve.
Second.
Motion and second. Is there further discussion on this item? Seeing none, roll call vote.
Rich.
Aye.
Ron.
Aye.
Jim.
Aye.
Travis.
Aye.
Kathy.
Aye.
Charlie.
Aye.
Sandy.
Aye.
Motion carries. Item 13.
Agenda item 13 is preliminary plat 20-18 to create tract 1 of South Caputo addition in accordance, the applicant is H&H Land Company. Agent is Brian Hammerbeck. Surveyor is DC Scott Surveyors. The applicant's agent, Brian Hammerbeck, applied to create tract 1 of South Caputo addition. As the property sits today, it is zoned general agriculture district consisting of 90.41 acres. There is special flood hazard area on the property. Takes access off of St. Germain Road. Contains a 40 by 60 pole barn, a single family residence, and a 24 by 24 detached garage. The proposed lot, as you can see on the screen, is the portion that's highlighted in green. That is tract 1 of South Caputo addition. It will continue to be zoned general agriculture district because it will be 40 acres. Will contain special flood hazard area. Will be vacant of structures and will take access off of Derby Lane. The request was sent out for interdepartmental review. County Highway Department, the addressing coordinator, and Register of Deeds all had comments that are included as conditions of approval. If you recall, the Planning Commission and the Board of Commissioners have seen this request before back in May of this year. At that time, when it was submitted, the parent parcel was actually 3 separate lots. And one of the conditions that was approved for that layout plan was that prior to filing the plat with the Register of Deeds, the remaining unplatted portions of the 3 parent lots would need to be rezoned appropriately to include a comprehensive plan amendment or an approved lot size variance be obtained. To address that layout plan condition, the applicants actually combined all 3 of those lots into one and are now subdividing through this request. So the creation of this lot will increase density of Derby Lane, and the applicant will be required to improve Derby Lane to Pennington County road standards or obtain an approved subdivision regulations variance to waive these requirements. And the applicant did apply for that on June 16th of this year. And it will be heard at the Board of Adjustment meeting on August 4th. As I stated, County Highway, Floodplain Manager, and Register of Deeds all had comments that are included as conditions of approval. The proposed lot does not appear to reduce the size of the existing lot below the minimum size requirements for a general agriculture district. Therefore, staff finds no significant issues with the applicant's request, as it appears to be in harmony with existing lots and current land uses in the area. And staff recommends approval of preliminary plat 20-18 with conditions.
Thank you. Are there questions on this item? Go ahead, Charlie.
Jason, and I assume that you're going to have to wing this a little bit, but under county environmental planner, it says no septic information could be found for the existing house. And I assume that's no negative.
Correct.
That mean they don't have a permit, or do they have a permit, or
Right,
what?
so they have a permit for the on-site wastewater construction, or the
Okay.
construction of an on-site wastewater system, and they have that in place, but they don't have an operating permit. And because this is zone general agriculture district, they're not required to have one.
Okay,
So when he states that there is none, then there doesn't need to be.
which would follow the rule, or following on number 10, your page 7.7, the following platting, any on-site wastewater treatment system subject to this section, et cetera.
Correct, for the new lot.
In other words, you don't want to do that until after, but wouldn't we normally do that before?
We do that as part of the building permitting process. So
Okay.
if they were to come in and subdivide this further and put structures on there, then we'd require the on-site wastewater treatment construction permit to be approved, or at least in works before we'd approve a building permit.
Okay, but the 40 acres is enough to keep it from following the...
Yeah, so per our zoning ordinance, if you have 40 acres that's zoned general agriculture, and it's used for general agriculture purposes, you don't need an operating permit.
Okay, has that been reduced then? Catch me up, Brittany.
Oh, no, you're good.
Question
So
I
the
missed,
parent
sorry.
parcel wouldn't be because it's an unplatted and it's over 40 acres. The new tract one, because it is platted, and even though it is 40 acres, it would require the operating permit. So it'll actually get into the system once the structure is built on there, or if there's a current structure on there.
I see, so it ends up, as he was saying, by the rule catching it through the building permit process.
Correct.
Okay, thank you.
Say, Brittany? Could you, gentleman here for number 12, we approved that, so he doesn't really have to wait if he doesn't want to.
Actually, I have business with him afterwards.
Okay,
So he's hanging out.
okay.
Yep.
Further questions on this item? Please come up to the dais at the...
My name is Brian Hammerbeck. Jason's been helping me through this. And just a clarification point for me, and it's really on recommendation. Number 3, we've applied for the variance. Derby Lane comes in from the west to the east into this 40 acre. This is part of 4,300 acres that we have out there. And it's a bare hayfield right now. If we don't do, and we've applied for the variance because that's what Jason recommended we do. What I don't understand, I just want some clarification on, is if all we leave this at is a bare hayfield, what is the reason that we'd have to improve Derby Lane to get this done? If all we do is leave it as a bare hayfield within our big range. That's what is that just part of the requirements? And
So by our ordinance, you're increasing density on Derby Lane, like you're stating.
by doing this, you mean?
Correct, you're increasing density by adding that lot down there.
Okay.
So that's the reason for it. So you're stating today that it could be used as hayfield, but in the future, it could be utilized, it could be subdivided further, it could be utilized as residential.
So that's a great idea. So my thought, I'm a practical farm kid. So if I come in there to ask for a building permit to build a house on that, wouldn't that increase the density at that time? And then that would trigger the requirement to increase the density, which would require Derby Lane to be increased? That's the point of clarification that I was looking for. But maybe that's just not how it works.
So even if you weren't to subdivide this property, if you were to put a house on this proposed tract 1, then you would still be increasing density, and at that time you would need to.
Say that again, Jason.
So even if you didn't subdivide this, you're still increasing density on Derby Lane, even if you were to put a house on this.
If I wouldn't put a house on it, how would I increase the density on Derby Lane?
By having this tract created, you have the opportunity to put a house on there.
But I wouldn't have to get a building permit to put a house on there?
You would.
So until I get that building permit, I can't increase density, or maybe I'm just not tracking with how that works. I'm not trying to be difficult. I just want to understand.
Mr. Chair,
Go ahead.
So Brian, let's just say you take the 40 acres and you subdivide that into 10 4-acre tracts.
Yep.
Although you haven't created an increase in population, you've increased density just through the fact that you have 10 lots that you can legally build on. And I think that's what Jason's trying to tell you.
And that's the same situation now, just by creating this one lot, you're increasing density.
The density is created by the lot, not by the building
Population,
permit.
right.
Correct.
Oh, okay. Huh, interesting.
That's just the statute,
So that's how the statute works.
standard operating procedure.
Okay. Go ahead.
As I understand it, you're suggesting that the first permit should trigger it.
Well, I'm a practical person. Density to me is somebody being there, using that. I mean, but if it's the lot that creates it, not the building permit, I guess that makes sense to me now. And that's what it is. I don't know that it makes sense, but that's how it's written, right?
That's how it's written.
But you have applied for
Roadmap, we got to follow.
you have applied for the subdivision variance, correct? To improve the road, is that?
That's correct.
Yes.
Okay.
And then is that in front of the commissioners, Jason, on the 4th?
That goes directly to the Board of Adjustment on the 4th?
Board of Adjustment on the 4th. And then do we have commissioners after that?
No.
Just Board of Adjustment on the 4th?
Correct.
And that's here?
Yep.
Okay, cool. Thank you.
Yep.
You're welcome. Further questions on agenda item 13? Seeing none, staff's recommendation is for approval of preliminary plat PL 20-18 with 11 conditions.
Move
Is there a
to approve.
motion?
Second.
Motion and second. Further discussion? Seeing none, roll call vote.
Rich,
Aye.
Ron,
Aye.
Jim,
Aye.
Travis,
Aye.
Kathy,
Aye.
Charlie,
Aye.
Sandy.
Aye.
Motion carries. Brings us to item 14.
Good morning, Commissioners. Item 14 is a conditional use permit, CU 2016, to allow for the sale of agricultural equipment and supplies in a heavy industrial district. As the property stands today, it consists of 6.23 acres. Access is off of South Interstate 90 Service Road. There's no special flood hazard area on this property. The lot does contain a 32,000 square foot storage warehouse built in 1958, a storage shed, and a 64 by 144 warehouse. Woodstock Supply is still in operation on this site. The considerations for a conditional use permit request, there are 5 considerations. I will read the answers to these considerations. The proposed use of the sale of agricultural equipment and supplies in heavy industrial district should not affect the use and enjoyment of other property in the immediate vicinity for the uses already permitted. The subject property is surrounded by Rapid City limits and Box Elder city limits. Rapid City's heavy industrial district allows farm implement and machinery sales as a permitted use. Staff cannot predict the impact the proposed use will have on the property values in the immediate vicinity. The current permitted uses in a heavy industrial district, as staff feels, is more, could be more, I guess, impactful to the neighboring than this conditional use permit. It appears that by allowing this conditional use permit, the use should not affect the normal orderly development or improvement. The proposed use of the sale of agricultural equipment and supplies in a heavy industrial district should not require any utilities or facilities that are not already in place. The zoning ordinance requires 1 parking space for every 50 square feet of customer service area, plus 2 per 3 employees based on design capacity of the largest shift for wholesale establishments and business services. There is ample space on the subject property to accommodate the necessary number of parking places. And the proposed conditional use by its very nature should have limited odor, fumes, dust, noise, vibrations, and intrusive lighting. Staff did visit with the owner of the property. He said he doesn't anticipate heavy traffic for this. So staff did recommend approval of this conditional use permit with conditions.
Thank you. Are there questions on this item? Go ahead, Kathy.
Brittany, I have one question, and, certainly I agree with your analysis of comparing this to these 5 factors, and there shouldn't be any problem, but, when I look at this ordinance, 212, and I look under conditional uses, the ones that are listed, there's no retail listed there. So I don't quite understand how, how this can fit with, under these conditional uses? Or is there some opportunity to add to those conditional uses as, you know, as it, to meet these if they meet the criteria?
Correct. Most of those conditional uses that are in those sections are examples. If you go to section 510, they look at, you can essentially have a conditional use. You can apply for a conditional use in most zoning districts, but you have to look at the underlying use to see if that conditional use permit is appropriate even in that district. So staff felt that since the location of this on a I-90 service road and the existing uses that are in the area, that this conditional use was more appropriate than actually the permitted uses in heavy industrial district. We felt that they would have, this conditional use would have, in fact, less impact on the area than the already permitted uses under heavy industrial.
I see. Okay, thank you.
Further questions?
Madam, or Mr. Chair.
Go ahead, Ron.
Over the years, I've appraised most of the buildings out at Exit 61, and this one here is definitely, when you look at the surrounding area, you got the I-90 cold storage. To the east and to the west, you got an RV sales, and across the street, you got Jenner Equipment, and so it is in harmony with the surrounding land use, with the exception of Wautuki, and that's not going to bother Wautuki.
Further comments, questions on this item? With that, staff is recommending approval of conditional use permit 20-16 with 7 conditions. Is there a motion?
So moved. Second.
Motion and second. Further discussion? Hearing none, seeing none. Roll call vote.
Rich,
Aye.
Ron,
Aye.
Jim,
Aye.
Travis,
Aye.
Kathy, Charlie,
Aye.
Sandy.
Aye.
Motion carries. Brings us to item 15.
Item 15 is conditional use permit review, CU 1922, to review an existing residence to be used as a vacation home rental in a suburban residential district. This item was in front of the Board of Adjustment because it is a vacation home rental on a lot of less than 1 acre. The board did have a review of this variance after a year, and the board did make the recommendation that this get sent back to the planning commission to add a condition to this conditional use permit, since there was a variance on this property for less than 1 acre for a vacation home rental. They had asked that the planning commission add the condition that upon the sale or transfer of this property located at 135 Swiss Drive, this conditional use permit automatically end, because it does have that variance in place, and the facts and circumstance that that variance was approved was based on the current ownership. So staff is recommending approval of the extension of this conditional use permit with 14 conditions.
Thank you. Are there questions on this item?
Brittany,
Yes.
page 5 of 6, the picture, and then we allow 10 people to stay in there?
Yes, that is actually in the Idlewise development. The Idlewise development does have a lagoon system. So
Okay.
their lagoon system is sized appropriately for the number of,
Just talk to the size of the building.
yes, there is
That was
small rooms and a
fairly small.
loft.
What, I didn't notice the dimensions or anything
Yep.
on here, but it looks so small. Looks like a 2-car garage or less long.
It's actually a little bigger than I think that the pictures,
Okay.
They stack them.
yeah.
Bunk beds.
They stack them.
I'm just saying, and it just looks small for 10 people to comfortably stay under our regulations.
Further questions?
Move to approve.
Second.
Motion and second for approval. Further discussion? Hearing none, seeing none. Roll call vote.
Rich,
Aye.
Ron,
Aye.
Jim,
Aye.
Travis,
Aye.
Kathy,
Aye.
Charlie,
Aye.
Sandy.
Aye.
Motion carries. Item 16.
Item 16 is a plan unit development review, PU 0518, to review a plan unit development to allow 1 acre minimum residential home sites off of Bradsky Road. This review was requested by the Cedar Gulch Number 2 Water and Sanitary District because they did have concerns with some water connections in this subdivision. This subdivision was in front of you at the previous planning commission meeting. They had requested to subdivide some of this property to allow for an additional 7 lots. With that subdivision, this board did recommend approval of that with conditions on to the Board of Commissioners. But after the last planning commission meeting, staff did receive an email and a request to review this PUD based on additional information regarding the water system that was out there. So staff is recommending approval of this PUD based on the review. The representative, excuse me, from the Cedar Gulch Water and Sanitary District is in the audience for discussion. Staff is recommending approval of this PUD with some change in some conditions based on the additional information. So I will let the representative.
Okay. Christina Grinnell, did I get that right? Just speak into the mic, that way Jim can hear you.
Okay. What we're requesting is we recently created a water board. So we're an official water district, but in doing so, we got a grant from the state of South Dakota that put some restrictions on us. So the water district is required to own the water systems that are in all of the homes because we have radium in our water. And so what we discovered is we have, according to our bylaws and according to some bunch of research that was done, we have 16 lots total that the well that we have can service. And we have 13 homes out there, which leaves 3 homes left to go. And in conversations with some folks that are trying to develop out there, we realized in conversations with the county that we're a self-governing body, that we kind of manage and maintain and do all of our own stuff out there. And so the question became, how would anybody know that we have to own the systems and what's going on with the water if nobody can tell them? So we are asking to add into the planning development just the approval of the water district so we can guarantee that they know that these things have to happen. Because we found out accidentally the lady at Water Tree was very gracious, and one of the developers came in to ask for quotes on the water system, and we're not, according to the state, putting Water Tree systems in. And so we discovered that there was no way for the developers to know that they need to visit with the water board to have a conversation with the water and sanitary district. So we're just asking that we add a line into the approval process that the water district can just simply be part of the approval so that they know that we have to talk to them, and then we can let you know, hey, we spoke with them, they know what they're doing, and then they can move forward before they build. Kind of what needs to happen with that. Because what happened before is we have 3 homes or 4 homes that were built in the midst of the water district being formed that had the wrong water systems pulled in. And we had to pull their water systems out and replace them for no reason other than the state required, according to our grant, that all the water systems were owned by the water district. So.
There's nothing that showed up in the title search?
My understanding, based on the conversations that we've been having, that the developers, when they come to develop, they have no idea that they're supposed to, what the conditions are. The bylaws, I'm kind of new to the president thing for the water district. The original understanding of the president prior to myself was that if we turned our bylaws and our minutes into the auditor's office, that information was updated with you all. I've since then found out that I've just simply been mailing the bylaws and the minutes to you all. And you're like, why am I receiving all of these bylaws? And not to you all, to the auditor. That because we're supposed to contain within ourselves. And so we're just asking that a line be added in there that the approval of the water district is a portion of the PUD, just so that we can make sure that conversations are happening the way they need to happen.
May I continue, Mr. Chairman?
Go ahead, Sandy.
So you're saying that the bylaws are not recorded at the Register of Deeds office?
They are. They've all been turned in
Okay,
before.
so when a person buys a lot, and gets a title insurance policy, those bylaws that outline the water system would be available to them.
We made that assumption as well, and I have visited with the gentleman that has purchased two of the lots in our district,
Uh-huh.
and he was not made aware of any of it. So we're kind of trying to find
Okay.
another avenue.
He was not made aware. Does that mean he didn't get a title insurance policy, or he didn't read the title insurance policy, or didn't show up?
I only know that he was not aware.
Yeah.
I only know,
think-
I only know that he was not aware. And he and I have had extensive conversation, and he was aware that there was a water problem. He was aware that there was a water district. He was unaware of the conditions under the water district bylaws.
Yeah, I'm just saying, many people that buy property, they don't bother to read the title commitment.
I understand.
So, okay, thank you.
This adds a stopgap, I think. It kind of helps make that, in my opinion.
Yeah.
Mr. Chairman?
Go ahead.
Christina, when you say developer, do you mean the developer that sold the lot or the contractor that bought the lot or possibly owner that's going to then build on it?
So-
You're losing me a little bit.
Nope, that's okay.
Saying the developer doesn't understand.
So we had two lots that were open that were owned by the Howie family.
Okay.
They sold them to a gentleman named Mark Haberman.
All right.
So, and Mark Haberman he purchased the lots for investment properties. His brother owns a construction company, Steve Haberman, and he will be building on these two properties as investment properties to be sold.
For the ones that weren't.
And they are the ones that were not aware. They have information that was provided to them by Gordon Howie and his family. But the Howies are not involved in the water district, and so they would not have updated information. They don't live out there, so they're not a part of the water district. They don't come to the meetings. They're not in the loop, if you will, of any of the changes that have been made since they developed on the land originally. So.
Right. And then my second question, your water district, as it's structured right now, does not plan to expand to service any of the other lots?
We cannot. The well won't support it. So we have 16 lots that the well will support, and that's about it. And that's about as far as that goes. So unless there's a new well, our water district cannot support additional land.
Go ahead, Kathy.
So I just have a question. I'm looking through the recommendations, and it appears that there's two that address your issue, number 2 and then number 9. And do those two conditions, do they really get at what you're trying to accomplish?
I have no idea, ma'am, what I read. Thank you. I read what you emailed me.
I have the same question, Kathy.
Can I
Go ahead,
try
please.
to answer? Sure. So when we looked at this, or when staff looked at this, we have to look at what's in our ability to have oversight. Under number 2 in our subdivision regulations, that does allow us to require approval from the water district or the water supplier. Because they are over those 15 lots and 25 people, they do have to have approval from the state. They are a regulated water system with the state of South Dakota. So number 2 would allow us to have that oversight of any further platting. Now, what's already been platted prior, there's, where it's kind of, we're in the kind of a middle, those 2 lots seem to be kind of stuck, in the middle of this plan unit development. But any further platting, hence the 7 lots that are being requested later, they would either have to get approval from the Water and Sanitary District to supply those as part of the platting process, as part of the subdivision regulations, or they would have to get a subdivisions regulations variance approved by the Board of Adjustment to allow those lots to be platted. And then number 9, that was already a condition as part of this plan unit development. It did say that it would need to be created. Now that it is created, they would need to remain active because there is obviously a water system out there that needs to be maintained and monitored. When they do these water and sanitary districts, they are their own legal entity. They are able to get grants and have assistance from the state and things like that. So those are the 2 conditions that staff had added that are, in harmony with what we can do as part of this zoning district under our zoning ordinance and subdivision regulations.
Mr. Chair,
Go ahead, Ron.
relative to the water system, you said it was designed for 16 homes. How do you rate that? How do they determine that volume and capacity that won't service any more than 16? I just wondered what they use for formula to arrive at the 16 home sites.
I only know that in the formation of I wasn't expecting to answer those questions today, I'm so sorry. I only know that in the formation of the water district, we had an engineering company come out and they did, what the well capacity was for the homes that were there in the development. And what their assessment is, that the maximum that we would be able to handle was the 16 lots that were currently platted. And so then we made the bylaws and established the water district according to the 16 lots based on what the engineer's report said for what the well could do.
Is that a pressurized system then? Or gravity fed?
I know there's a pump and a pump house, and I know that I have no idea, if I'm being honest. That's a boy question. I have no clue.
Brittany, another question. What would, if they did additional lots and these lots couldn't tie into the existing water district just because they don't have the capacity, then what would the alternative be? Could they create another water district out there, or cisterns, or another well?
So I have spoke to Mark Mayer with South Dakota Department of Environment and Natural Resources. He is the drinking water administrator. He did say that it is a supply and a quality issue on both out here. So they would essentially have to drill another well that could either serve all of them or, be in conjunction with the existing ones. They also have to have some treatment, I believe, treatment on the individual taps, hence why the district owns, the water system and things like that, because there are certain requirements that they are required to do under state regulations for the drinking water quality. With that, they would have to develop another water source that would be approved by the state. As part of the PUD process and as part of the planning process, that is something in our subdivision regulations that is, required under that, because when you get over those 15 lots, that
So if this is
regulatory.
approved today, there's a lot of safety mechanisms that would keep any development from happening without adequate water.
I believe from our perspective, we have done what we can under our zoning ordinance and our subdivision regulations to address their concerns, what other avenues that they could have as the sanitary district, they would have to do through title search, register of deeds, any kind of filing like that would come up. But we've done what we can on our end.
Okay.
Brittany, I have some clarification questions. So the 16 platted lots, did those include the 7 that we approved as a result of that court order? Okay,
No.
so those lots will sit there. Those won't be able to really connect to this water system.
Correct. So the way that this PUD is written and, with how we are recommending it, that we would have to get approval from the local water supplier that they could actually connect those 7 lots. If we didn't have that, then they wouldn't be able to file their final plat, or the Board of Adjustment would have to approve subdivision regulation variance, allowing those to be platted. The struggle if that happened is now we have platted lots that there's a couple issues out there with the ingress and egress and then the water system.
Is the engineer for the developer, Long Branch, aware of the water issue restrictions?
They have received all of the information and the information that we have gotten. As part of that plat, there was some land exchange requirements. The reason that they were being platted, the SAO has reviewed that and believes that there may be an alternative for that exchange.
Okay. Go ahead, Charlie.
Add in a little bit to what you were saying, Brittany, to Ron. There's a great difference between an individual water supply for a lot and a household versus the system. The state is the only requirement for the individual house supply. You're tested once, and you're not required to ever test your water again, whether it's a cistern and it has to meet a specific test, which is considerably less than what the system has to meet under the state. But the system also, when they get to certain numbers, has federal requirements. So they expand beyond that. So to answer your question, yes, they could go to an individual well, even though they're aware of some quality issues. And the state test may not catch their quality issue. So it is involved here. It would appear to me, though, that adding your say-so in this won't help you. I think your board's just got to turn it down, period.
Well, I guess I want to clarify, I'm not talking about the 7 new plotted lands. I'm talking about, because the plotted lands in there, we've already learned that the people who are buying the land that's already platted, that doesn't have a home on it, are unaware. So I'm just adding for the current the platted lands that are in there. I know that it's covered for the lands that are not already, but it's the open land that can be purchased. So if you came out into our neighborhood and you purchased the land that was the other 2 lots that are available, that are under our district, unless you know you're supposed to look in all of those places to discover what was supposed to happen. You're going to build a home. You're going to go to Water Tree, because that's what's been happening. You're going to put a $10,000 water tree system into your home. I'm going to knock on your door and I'm going to say, "Hi, Mr. Johnson. It's so nice to meet you. I'm Christy Grinnell. I'm the president of the Water District, and I'm going to need to tear that $10,000 system out. Good luck selling it. I'm going to put in our $5,000 Culligan system." I have some very angry neighbors because that's exactly what happened. And so we're just trying to find an additional level that says, we're not going to just not approve people moving into that neighborhood. It's more of a, hey, by the way, did you talk to your water district so you know you're getting the right systems put in, that you're handling your water the right way on the lands that are already platted within that neighborhood. We're not trying to take over or, be controlling of it, just an additional step that says you have to come talk to me or one of the other board members so that we can make sure your house is built properly and your water is taken care of without me tearing out a system that you just paid to put in your home.
But I was suggesting that that's a state requirement, not necessarily a county or a building requirement that's in our sphere of things. Your state requirement because of funding
Okay,
and because of your operations with your water quality, which
Sure.
has to meet a particular state level,
correct.
is the factor that's determining whether or not you can supply those and supply it in advance so that they don't build it and you tear it out.
Correct.
That was all I
How-
was suggesting.
Well, I guess my question, which is the question I've been asking for a few weeks now, is how do I find whatever powers that be get to notify the people that are buying the homes that are,
I'd be the wrong one
Do
to
you know what
advise it
that's-
legally. I don't think I can advise. I see some ideas in my head if I was a contractor or a property owner, but
I
I'm
understand.
just suggesting that that would be beyond something that I would want to do.
And what I don't understand is if they build their own private system, wouldn't that be nice? Then it wouldn't burden your system?
Because of the water district and the grant under which the water district was formed with the state is requiring that the water district own the systems, and that they picked the system that gets purchased.
By virtue of the fact that the legal description of the lot upon which people built their own private system is part of that grant?
The specific system, the Culligan H25290, that specific thing is what was, the state required that we had to get quotes for the water systems. That we had to submit those to the state in the formation of the district. The state selected the less expensive of the 2 systems. So that system is required to be in the home. We've tried to move around it because we've had some homes that had a different system. The state wanted, that had to be the system that they approved.
You're talking about what if they opt to install their own
We've,
water system,
She's
not
saying that they
connected to
have
yours?
installed their own system.
we've been told by the state that they can't do that. The water
They
district
couldn't
has
drill
to.
their own well, they couldn't put
They
their
could drill
cistern
their
in.
own well. Yes, they could do
Okay.
that. If they're within
was-
our water district using our water,
My point.
I'm
If they-
sorry.
If they, that's what I thought
I
you were
misunderstood.
asking.
No, I'm just saying,
Okay.
she's saying they built their own system, but yet they'll go and tear it out and put in a different system. And I'm just wondering why Why would you have to do that?
We've been asking that same question for a few months now, ma'am. That the state is requiring that the system that they will approve is in the homes.
Sorry, I misunderstood.
I misunderstood your question. Yes, if they trucked their own water in with a cistern, then yes, they could do whatever, they're no longer using our water. They could do whatever they
And they can meet their
wanted.
state requirements for billing, is what I'm saying.
That
They
is
still have
correct.
that option.
That is correct. Yes, if they don't want to use our water.
Further questions?
Mr. Chair,
Go ahead, Ron.
can the water district expand? Can they add more wells in the future to take on more homes?
So my understanding is that there is based on what the engineering report told us, there is a well that is between us and the 7 platted plots, which is, for your edification, is probably the best way to put it. That is a significantly better well, that well could be drilled, and then we could expand the district and would happily do that to accommodate new people, so a new district didn't have to be formed. But we do not have the district currently that we have, don't have the funds to do that well, and the well we have suffices what we have. But we're willing to work with the future and move out. It just won't work off the well that we currently have.
Okay, thank you.
Further questions?
Thank you.
Thank you.
Seeing none, staff recommends approval of planned unit development PU 0518 with 10 conditions. Is there a motion?
I'll move approval.
Second. Motion and second. Is there further discussion? Seeing none, hearing none. Go ahead, Charlie.
This is a review, is it not? We're not doing any new conditions. This is a review of the existing one.
There were some changes to conditions. Number 1 has changed, number 2 was added, and number 9 has changed.
Okay. All I brought that up is because I wasn't aware, you said that this had been approved just recently.
Well, it was approved, I think the last review was in 2007, I believe, because it was on a complaint basis only. So that's why it was brought up for review, because they filed a complaint with our office to address some of the water concerns.
Oh, just that 7-lot thing was what was done recently.
Correct. That was a layout plan that was done
Cleared it up
recently.
for me.
Okay.
You brought me up to date.
All right.
Further questions? Seeing no further discussion, roll call vote.
Rich,
Aye.
Ron,
Aye.
Jim,
Aye.
Travis,
Aye.
Kathy,
Aye.
Charlie,
Aye.
and Sandy.
Aye.
Motion carries. Item 17.
So item 17 is Ordinance Amendment OA 20-05 to amend Section 510 Conditional Use Permits, to amend and supersede the existing Section 510 of the Pennington County zoning ordinance. This ordinance amendment was done to update and amend Section 510 because state statute did change. So the appellate scheme and the standard of review for conditional use permits had changed, and our zoning ordinance actually conflicted with statute. So we needed to amend this so it was in harmony with what the statute requires. Just one thing to note, that prior to the statutory change, conditional use permits were able to be appealed and go to the Board of Commissioners. Now, because of the statute, if the appeal must go to court by a writ. The attorneys in the room can speak more to that if you have questions about that. But just be cognizant of the fact that the decision of this commission would be appealed to court. And that was something that Rich and I had spoke about because of our consent agenda and our regular agenda. You will not see new conditional use permits any longer on the consent agenda because we do need to have a meaningful hearing. They do need to be heard, and the factors for those considerations of those conditional use permits need to be addressed and considered by this planning commission and not on consent. The other thing that had changed is on section D, we had expanded the criteria and basically how we will apply those criteria to each of those standards of review. And so there is the application guideline. That is something that the applicant is going to have to put on their application, how they're going to meet that criteria, what is the basis for their conditional use permit. So then that way, when we present it to you, like some of the questions that, you know, are asked on a regular basis, does it fit with the neighborhood? Is it in harmony? Is it a use that's appropriate in that vicinity? So those are some of the major changes. So I'll entertain any questions, and also legal is here.
Mr. Chairman.
Go ahead.
So that was probably the one question I was going to have is how is E, how is that really? Because all those legal terms, I started thinking, oh, what is this going to look like? So I would definitely like to understand that a little bit better. But if I understood your layman's terms is if there's an appeal, it goes to court?
The changes, the prior ordinance provided for an appeal from this body to the Board of Commissioners. That is in fact based upon recent legislative changes within the last two years, an illegal appellate scheme. Under the current statute, conditional uses are appealed by a writ of certiorari, which is a review. It's just basically a review to make sure that the body acted legally within their authority, to circuit court. So by statute, conditional uses, if the Planning Commission is the deciding body, then the appeal is by writ to circuit court. And that's one of the reasons this is being changed. In fact, this change is occurring across the state because of Senate Bill 157. The other thing I would like to point out with regard to Section 510 is these are the conditions that are going to be applied to more of your generic conditional uses. There are other conditional uses that have much more specific and demanding criteria, and those can be decided differently. For instance, our mining ordinance, aggregate mining, you are only a recommending body with the Board of Commissioners being the deciding body. So there are certain other types of uses that are deemed conditional uses, but they may be wind farm, mining, that are more specifically addressed by their own individual ordinances. But this criteria will just be more for your generic conditional uses that are not otherwise addressed by a specific ordinance.
Question, another one, if you don't mind.
Go ahead.
SB 157, was that done just this year?
Yes.
Okay.
But also, I will say, actually, 2 years ago, there was an amendment to the statute which came to our attention about a year ago, which also created that writ of review. So we actually have been advising people who were appealing to also seek a writ because we didn't think this ordinance was any longer enforceable. So, but yeah, it's a result of legislation.
Okay.
Question, so how does that, let's go through a scenario. We have a conditional use permit come forth. It gets denied. They appeal that to circuit court. Are we all answering questions to a judge in circuit court? How's that go down?
No, you are not. That could have happened under the old appellate scheme. That's a very good question. Under the old appellate scheme, where the appeal went from this body to the Board of Commissioners and then to circuit court under just a regular appeal format, then that would have been a trial de novo, which would have been a whole new trial, and you could have actually been subpoenaed to come into court and testify.
Okay.
Under a writ, I don't have the case law in front of me, but it's a very narrow review. They're basically making sure that you acted legally, and that's about it. It's a much more narrower, and it's not a trial.
So the judge would look at whether or not this board reviewed items 1 through the criteria 1 through 7, and if we did and we made a decision based on that and gave reason why for the denial, he would review that, determine whether or not we were following the law, and that would be it.
Pretty much, and that's why I really like seeing the discussion that I've seen both at the Planning Commission level and the board. I've seen a lot more discussion about the criteria and the pros and cons and listening to neighbors' complaints and really trying to apply the criteria to the evidence that's being presented before the deciding bodies. But that's exactly how it would be. That's how it would play out.
Thank you very much. Charlie, I think I interrupted you. Go ahead.
I had the same question. In other words, once we do the writ of certiorari, is it a full-blown hearing?
No.
Or is it a judge reviewing this, asking the sides if he has questions in regard to his review?
The judge, it's basically a review based upon the written record. So everything that's taken down here is transcribed and sent to the circuit court, and the judge simply reviews the written record.
In other words, we better handle it much more cleanly and for the record than perhaps it has been handled in the past. Certainly not these folks. They've already done a wonderful job. But I'm just suggesting for the future, we might want to look at how we conduct ourselves individually in regard to these 7 issues.
Yes, and I'm, Mr. Johnson, my name's Michelle Hoffman with the State's Attorney's Office. Unfortunately, I'm leaving here in a week. I'm joining the U.S.
That's what
Attorney's
I read.
Office. But that's spot on. In fact, that's one of the reasons why Ms. Molitor and I tried to really flesh out the conditions for you as well, and also for the applicant, so they could see how those conditions would apply. So we ensure that they provide the relevant information.
Okay.
Thank you.
Further questions?
So I have a few questions, but on that point under appeal, who can appeal? Can anyone appeal? Does it have to be, I mean, can anyone appeal other than the applicant, or how does that work?
If I recall, and again, I don't have SB 157 in front of me, there were some slight changes. I think it has to be an aggrieved party under the legislation.
But it's specified in the state.
Yes.
Okay.
I know there was a lot of back and forth with that on the aggregate mining, the ordinance that went through, but in this instance, it's controlled by statute.
Oh, I see, okay.
And they even provide a definition of aggrieved within the statute.
All right.
And that's also why I just generically referenced Chapter 11-2. That way, if there are any future changes to the statutes, we don't have to come in and necessarily amend our ordinance. We may need to tweak our process, but.
Okay. So may I, Mr. Chair?
Go ahead.
Just continue. So I was so I have kind of a question on the review part of it. And so, I mean, I remember some issues where we were a little bit confused in the past several years about when the review is up and if we deny an extension of conditional use, does that result in a revocation? I mean, if you deny a review, is that the same thing as revoking the conditional use?
What particular section are you looking at?
Well, I mean, I have that question under section, it's F, paragraph F.
Oh, I is the section that
Yeah, that's
would.
the revocation, but
Yes.
I mean, under the F is review, I mean, usually the recommendation is to extend the review or extend the conditional use. But what if we deny it? Is that the same as revoking it?
No, because the review, the way I'm looking at this is a very good question. We may want to look at this closer to make sure that those two provisions work together. This review is just if we get a complaint basis, that type of thing. But on the revocation, if we're actually going to revoke, we're setting, which is a significant property interest, we're actually providing for a noticed hearing, et cetera.
But the reason I'm thinking of this is when we were doing all the reviews on the Spring Creek, or the Spring, whatever, the bed and breakfast and the event center across from Pactola, what am I thinking?
Summer Creek.
Summer Creek, yes. I mean, the concern is if we didn't, it was a review, and if we didn't approve an extension because of some of the conditions, they would essentially lose it, and they'd have to go out of business like tomorrow. And remember that? And it was.
I do not read the review as being this. You might have a review that might lead this body to decide, well, we need to have a full hearing, because the review does not require the 10 days notice that is provided in the revocation. So I think the idea, and if it's not clear, we certainly can look at it and try and change it a little bit. The idea with the review is just that you can have a review on a complaint basis. The board or this body may bring it forward, or the planning department, but it's just for initial review. I would assume And the way I envision it is if anyone is so inclined to in fact revoke the permit, that then we'd move forward to the hearing process.
But isn't our action at the end of those reviews to extend it?
Right, and I think because this is separated out, and in the past, I think they were able to end or be revocated. I think this revocation is something that because it basically says failure to comply with conditions of approval. That is someone that has repeatedly not met the conditions of their conditional use permit. Instead of just revoking it, having it done, they actually go through a hearing process now. So we could go through a review. And this body could say, we've reviewed this, it's continual, and we need to schedule a revocation hearing, because the revocation hearing would actually require notice, at which, the reviews do not require notice. The reviews right now are just on the agenda, and that's it. There's no notice to the neighbors, there's notice to the property owner, because they will get information from us, staff calls them, because they'll do a site visit and things.
Yeah, so in practical terms, what we're asked to do is decide whether after a review, or the item for it's called a review, we are asked to either extend the conditional use permit if we say yes. If we deny that action, if we say no, then we're not extending it. So what are we really doing?
So I think when you deny it, in the past, it would have been that way, it would have ended it. Now with this process, you would actually have to recommend to do a revocation hearing.
Okay, I think it would be helpful to add a little bit of language there so that it's clear to people like me when I look at these, try to figure out what's.
Well, I have a question for this body, and it's a very good point. I think our thinking was that if we're not going to renew this, and you're right, if it's denied, essentially you're not continuing it. But should we not provide a full hearing for that person? This is a new provision. We've never had the revocation provision within this ordinance. So that's also something, it doesn't have to be put in here. You are correct that in the past, the way it's been handled is if we don't deny it, well, you've just lost it. You have to cease and desist, but.
Well, I'm not saying we shouldn't have the revocation. I think that's a very good, it seems, on the face of it, strikes me as very sensible and appropriate and so on. I was just struggling with, I guess I was just struggling because of the past experience and how all this fits together.
I would suggest then that this body continue this, make a motion to continue. This hearing's been noticed in the paper properly. I'm thinking.
It was noticed at the board too.
It was also noticed at the board. That's something we could do. We can continue it, we can renotice before the board, or you can simply approve with direction that we clarify section F, that in the event that we could add something here, in the event that PUD is not continued, it would be scheduled for revocation. I suppose there are some PUDs that naturally are discontinued, but it'd have to be based upon the objection of maybe the applicant.
Brittany, we used to, and you were here then, the board would do what Catherine's talking about, and we'd get to the point where we call it more of a compliance with rules type of thing, and we always continued it and it was usually the next meeting that they had to come forward and kind of say whether they were going to comply with the rule or note what conditions they were going to provide to get within the guideline of what we'd established. If not, then we went ahead and did the complete revocation hearing. So it was always a two-step process, but it was a rule of thumb type of thing. We just never revoked, because you're correct. It was the way it was written. You drop the hammer, those poor folks were standing there, with nothing in their hand. We just never did that. So maybe there is a way to allow for, and then we used to make them notify their neighbors then too.
I think that was the idea behind this revocation provision too. There's a notification to everyone surrounding that property. That way, if there are significant problems, then the property owners can come forth and tell you what problems they've been experiencing.
And sometimes they're not experiencing problems.
Exactly.
They actually support it. We found that out when we would get to revocation hearings. I can remember several.
Right, and I think typically prior, because when we had that other appellate scheme, it could go to the board, and that's typically where the revocation would occur, like Commissioner Johnson is speaking, because either party would appeal it to the Board of Commissioners, and that's when that hearing, or that would be the deciding issue. Now we don't have that
Just so
necessarily.
much better than what, because I actually remember a Board of Commissioners stepping down, becoming a citizen and doing the appeal. He became a citizen, got off the dice here and went down, and he was the one that was appealing it to get it to the Board of Commissioners, which that looked terrible.
Well, we could add a sentence at the end that says, something to the effect that in event, at the planning commission's direction, a revocation hearing may be set or scheduled, something like that, or ordered. We could add a sentence to that provision.
But I think that'd be good, but I think in addition to that, I guess what I'm trying to understand, or the question I'd like to have answered, is that it's simple. If the recommendation is to extend the conditional use permit, and we say yes, that's simple. What happens if we say no?
Well, a lot of times I think you don't say no. The last 4 years, my recollection is that there may be a violation of one of the conditional use rules, but that person comes forward with proof that they've met that condition, or this body adds additional conditions. Very rarely is a CUP denied. It's usually, oh, okay, you're good to go, or you've met our
Well,
questions.
then I guess I would appreciate maybe exactly what you said, put it in here so that, many times it says that the planning commission either will approve, deny, or approve with conditions or something. And maybe it should, in there, explain what actions we're allowed to take, essentially. One, I guess we could approve, we could continue it to look into things, or we could ask for a revocation hearing or something. Just be a little specific about what our actions can be and what that means.
We can do that, and I think with that in mind, we can simply take this off. We can either continue it, or we can simply take it off calendar, make those changes, and bring it back before the planning commission.
Mr. Chair,
Go ahead, Ron.
I'll just recommend a continuance so we can get this worked out.
Second that, yeah. Along Catherine's guidelines, I think we're all thinking that.
Motion and second, further discussion?
I have one more question, if I may.
Oh,
This is
Ed, Kathy.
Oh, I'm
I was going to ask, I was going to say, I was kind of sitting here running it through my head. Like you said, Michelle, it could be something as simple as if the review is denied, then it starts the revocation process or something of that nature. Because usually if we continue it, we know we're going to see it on the end. If we approve it, we know what happens there. But if we just didn't take action, or if we denied it, then I think that's the biggest question. I think if it says it's denied, then that triggers, the revocation process. And I think it's a very simple statement in there rather than having to figure out a long, we have to take this action, this action, or this action.
But I think it needs to be clear also for people that come in with CUPs what the process will be for this board if things aren't followed. So I think having the process, the approval process, also I'll call it the correction process. You are not in compliance with the recommendations. Though you have this much time, and here's the current stipulations on the approval of this. And if they're not done by this date, then here, this would be the next step. So I think that the continuation is appropriate.
We could even add language that says upon request of the applicant, we would schedule a revocation hearing. I suppose if the applicant doesn't want the hearing, then no need.
I trust that you can solve this problem. Okay, so just quickly, I had a couple of other thoughts. Where am I here? Oh, yeah, on criteria 1, I noticed that in the old 510, the word nuisance is used as to make sure that it's not a nuisance, and here it isn't. And, personally, I always kind of took some comfort when I would read these ordinances and see the word nuisance, because, of course, we have nuisance statutes, and we could then draw upon that. And I just was wondering if somewhere in criteria 1, either in this application guideline or above, the word nuisance shouldn't be added to those lists, just so that it makes kind of a clear connection to the, the nuisance ordinance and so on. And
The reason it's not included in this particular ordinance, if you recall, we've had a few prior amendments to our ordinance that specifically lay out abatement, public nuisance. What we just realized is we're repeating several paragraphs of language, which leads into our amendment, the next amendment, dealing with enforcement of ordinances. And that one specifically says any violation of an ordinance resulting in public nuisance,
okay,
et
fair
cetera.
enough. The second thing is that, this kind of goes back to the question I asked about Mr. Vig's conditional use permit today about, there was no mention of retail on the examples listed in the ordinance under heavy industrial, and yet it met all the criteria. I just thought maybe as an introduction under D, criteria for evaluating conditional use applications, there should be something a bit more explicit about just what you responded to me when I asked the question, that in the ordinances, specific ordinances, that these are examples, and that conditional use permits can go beyond that if they meet these criteria. I mean, just something in general to answer that question.
Sure, and actually, Michelle just reminded me, we are bringing forth section 200, which will be in, not the next meeting, but probably the meeting after, and it is addressed under each individual zoning section.
Oh, okay.
That'll say that these are illustrative, and that conditional uses can be considered, in that manner.
Fair enough. Thank you.
You're welcome.
We have a motion and second for continuation, but I didn't hear a date. Is there a specific date that we would continue this item to?
Next meeting?
Is that enough time?
Yeah, I think it would be an adequate time.
Okay.
It's August 10th.
I'm sorry.
August 10th.
August 10th. And is the motion and second good with that?
That's fine with me.
Okay. Item 17, motion and second to continue this item to August 10th. Roll call vote.
Rich.
Aye.
Ron.
Aye.
Jim.
Aye.
Travis.
Aye.
Kathy.
Aye.
Charlie.
Aye.
Sandy.
Aye.
Motion is continued to August 10th. Item 18.
Item 18 is Ordinance Amendment OA 20-06 to amend Section 514 violations and penalties, to amend and supersede the existing Section 514. And this is to update and amend this section. Just as we spoke earlier, we were noticing that we were repeating this in every single section of our ordinance. So instead of repeating all these new sections, we're just going to refer to Section 514. The largest change in this section is under penalty fee. Currently, we had kind of a different penalty fee structure where they would be doubled for building permits. It would be doubled for other permits plus $500. We just did a straight triple the fee across the board for any violations or penalties if they're operating prior to an approved conditional use, if they build the structure prior to a building permit. So we just streamlined that penalty fee.
So we're making a new section. Do I understand this correctly?
Yes, actually, the penalties were in 511, which were fees. So we actually moved it out of 511 and put it actually in the appropriate section, which is 514, which is enforcement and penalties. Prior to that, 514 had only referred to the statutory requirements that under B is the only thing that was in the original 514. There was no information on abatements, penalties, or injunctions. Those were in each individual section, and like I said, the penalty fees were actually under 511 fees.
Thank you. Further questions?
I have one question.
Go ahead, Kathy.
Under abatement, and the answer to my question is probably in these other ordinances that are referenced here, or the SDCL, but there's a provision and a process somewhere for the county, once they spend money to do abatement, to collect that money, right, to recover that funds? And is that process then included in the South Dakota laws that you've mentioned here? Or where is that explained?
That is in SDCL 21-10-6.
Okay, so that's covered. Okay, thank
Right.
you.
So under that statute, just for clarification, so they know, there are certain requirements that we have to do as an office for notice. They do have the ability to go in front of the Board of Commissioners to argue that they, and have a hearing in front of the board. Currently, our ordinance is the only bodies that can declare a nuisance are the Board of Commissioners and the courts. We don't have anything in our ordinance right now that allows our office to do that. That will change.
That's part of the purpose here, which was discussed, I think, at the recent board meeting, is because we had to bring a particular public nuisance to the board to declare it a nuisance and authorize abatement and have the fees assessed. I believe the board has the authority to delegate that, but we need to have it in our ordinances. So that's what this does. This delegates to the planning director the ability to do so.
Brittany, can you just, I'm not thinking of building permits, I'm not thinking of septic permits, dirt permits. What if somebody decides to take a piece of property and they alter the thing regarding drainage, all the different things like that? What are we talking about are the fees that they have encountered that would be under this? In other words, is it enough to dissuade them from doing that?
Actually, this section is under our 507, which was just done. It would essentially be declared a nuisance because anytime that you would alter a property through dirt work, it typically would create a nuisance either through the drainage issues and things like that. So it could be abated under that.
Further questions?
Oh, and also, sorry, she just reminded me, under 507, we can request a bond. So for the larger projects, we can request a bond. And if
Could
they,
increase that bond under this?
Well, the bond's separate from this. This is
What I'm
just,
saying is if they did it in advance, if they broke the statute here.
yeah, the bond is up front before they even get their permit. Brittany can require, if it's a large project, significant monies to be held on.
right, but this would require triple the fee. So right now it'd be $250, so they'd have to pay $750. They would still have to get a permit. So that part of that permit review could be the bonding requirements. If they don't like, under the new 507, what the planning director requires as far as a bond, they would have to appeal that to the Board of Adjustment. So,
As I'm driving around the county, I'm seeing more and more of this dirt work getting done. And we have our 100-yard
it's 10,000 square feet.
10,000 square feet, okay. I didn't know what the current was, but a lot of folks, they jump the gun because it's financially advantageous to them. They're gonna make you figure out what they moved, in other words. And I'm seeing that up in the hills. And
The fees.
I'm thinking of the one I drove by all the time that was doing a whole lake. I think you guys pursued that one and got it in the program, so to speak. But there's others going on, and these folks, especially about moving dirt and changing drainage, they're affecting their neighbors. And I'm just wondering, $750 isn't a whole day on a front end loader. That's all I'm trying to get at in regards to dirt. We might have a particular category when it involves drainage and doing these things that's altering the hills, taking trees down, take mountains, that should be somewhere we should address that with a little excess versus a building permit or a septic permit. Just a point in my mind.
Sure, and if I could, we did change section 507, which is our erosion, sediment control, stormwater requirements. So there are different requirements now. Previously, they had to go in front of the planning commission and have that hearing. Now, it's just that through the planning director with an appeal to the Board of Adjustment. So those permits are getting turned around quite a bit faster. And we do actually have a staff member in our office that works with the property owners, try to, keep up on some of those dirt work. But unfortunately, some of them start before we get to them. We do get the complaints and then we, go that route. But that's one way that we've tried to streamline the process a little bit and get their permits turned around a little faster, so there isn't that concern, because time and equipment is money. If you have to wait and schedule a hearing in front of the planning commission, you're looking at 4 to 6 weeks out versus now, we can turn them around in about 7 business days of what we would a building permit.
I was just pointing out that the people that get in this box, that want to get out, if their contractor's sitting there already with his equipment that blows all the black smoke in the air, and they go ahead and do it, if the penalty is not enough, they're just gonna, it becomes part of the project cost.
Right, and
I think I'm seeing more of that driving around. It concerns me, especially with more and more stress or pressure to develop.
what has been effective for our office is if we do a stop work order, because that does take them out of the machine. So that typically is, and they usually get those things fixed and turned around pretty quickly.
That about the stop, we didn't used to have that.
Yes, and we do those now. We haven't had to do one recently. Most of the times they'll come into compliance fairly quickly, but we have done them in the past.
Notification is the primary deterrent right now for doing that. Okay, thank you.
Further questions on item 18? Seeing none, hearing none, staff recommends approval of Ordinance Amendment 20-06. Is there a motion?
So move.
I'll second.
Motion and second. Further discussion? Seeing none, hearing none, roll call vote.
Rich.
Aye.
Ron.
Aye.
Jim.
Aye.
Travis.
Aye.
Kathy.
Aye.
Charlie.
Aye.
Sandy.
Aye.
Motion carries. Item 19.
Item 19 is the county board report. The Board of Commissioners concurred with the Planning Commission's recommendations from the July 13th, 2020 Planning Commission, with the exception of the layout plat 20-14 for the Grand View. That is the Cedar Gulch number 2, that 7-lot plat. They did continue that till their August 4th, 2020 Board of Commissioners meeting based upon that complaint on the PUD.
Okay. Any questions on that? Seeing no items from the public, we will skip item 20. Item 21, items from staff.
We only have one. This is Michelle's last planning commission meeting. So that's our only.
We're gonna miss you, Michelle. We thank you for everything you've done for us to help us stay between the ditches, so to say. Anything else? Items from staff? Okay. Items from the membership. I don't want to extend the meeting any longer than necessary, but the question that got brought up today regarding the increase in density with respect to platting versus the home being there, physically increasing the density, is there I'm sure that there's a reason and a rule that it is not coming to my brain, but is there any thoughts on that, on why the rules are the way that they are?
Actually, yes, it's actually in our subdivision regulations. Our subdivision regulations, if you do any kind of subdivision of property, there are road improvement requirements. So that's typically where it falls under, is our subdivision regulations, which are going to be updated shortly also.
Sure.
So, but it is under the subdivision regulations. It is very difficult, just, from being in the office for a long time, having somebody buy a piece of property, they come in to get a building permit, and then you tell them they have to upgrade a road. It's very difficult to do it in that at that juncture. It's easier. I shouldn't say easier. It's more appropriate, I think, to do it during the subdivision of the property, then that way it's fall under the subdivision regulations. And then if they do want to waive any of those requirements, they can go in front of the Board of Adjustment to get those requirements waived or changed.
And where you have a subdivision of 8 lots per se, then you're putting the person who buys that first lot and builds that first home all of a sudden is being told they have to develop the road. I think the idea is that the developer is subdividing this into 8 lots, that the developer should pay the cost of developing that road. And obviously then that would get passed off to all of the subsequent property owners in their purchase price.
Or they have to post a bond to do it or something like along those lines. How about, and so we have something similar to that with regards to the sewer, right? We have septic requirements that typically get postponed, and now those are done at the time of the permit, right? Perk
Correct.
tests.
And that is something that staff has talked about. When those subdivision regulations went into play, we didn't have what went into effect in 2010 with our septic ordinance and our 204J. We have a more robust procedure. You know, we're looking at profile holes and percolation tests that weren't actually in ordinance at the time. Sometimes they were done, sometimes they were not. But now with that more robust procedure, it's probably not as necessary under the subdivision regulations as it is. Just from our experience, we were seeing, you know, that developers would go out, they would just dig a profile hole wherever. Those lots would be sold. Our ordinances require, and the state requires that the drain fields be within 15 feet of where their profile hole is dug. Well, now you just had a developer go through a whole process to do profile holes and perk tests, and then you have a purchaser that's not even going to build a house even near where that's going to be. So it just really isn't a good process. So that probably will be removed from our subdivision regulations, just because our septic ordinance has become much more robust in that.
Okay. My last question is following up about the letter notification. We were going to add some language to the notification letter, pointing the neighbors or the notifications to the website. Did that get done?
I haven't had.
I don't know if we've had any, have you done any advertising since that? So this Friday will be our advertising for our next round.
Okay. But you're going to put a sentence in there that indicates that they can review the agenda packet at this location prior to the meeting,
Online,
something along those lines?
Yeah, because I think I have some upcoming ones for some Board of Adjustment on the 18th.
Okay.
Yeah.
This was a conversation that Kathy brought up, I think, at the last meeting. So,
Mr. Chair.
that's all I have. Go ahead, Ron.
Brittany, I guess this would be a good time to bring this up. As a commissioner, and you've been with me on some of these where we go out to the property and we got that statement. One of the conditions is that an approved building permit be obtained for any structure exceeding 144 square feet or permanently anchored.
Mm-hmm.
I really think we need to define permanently anchored somewhere, because we went out to the site. The gentleman said, look, this is, it's 144 square feet. The question is what is permanently anchored? You know, he said, if I build this 100 square foot shed out of concrete, is that permanent? Because it's not permanently fixed, it's just a heavy. And it's just be nice to be able to sit there and say, this is what permanently anchored is, and this is what is not. The carports, sheds, and for assessment purposes, anything under 144 square feet, it's my understanding that, you know, it's not assessed. They don't have for assessment purposes. So between equalization and planning and zoning, I really wish we could define. So it's pretty subjective, and I get called on that a lot, so I wish we could work on that.
Okay.
So I could sit there and say, this is permanent, this is not permanent.
And typically, just as when someone calls the office, if it's on skids and it can be picked up and moved around, that's not anchored to the ground. If they actually, pour concrete footings in the ground and they build around the footings, we consider that. That's just our office policy, our rule of thumb, so to speak, of how we are addressing it. I know some of the concerns with that anchored, when speaking with that gentleman is it going to be assessed? If I anchor it, is it going to be assessed versus if I don't anchor it, is it not going to be assessed? And that's something I'm not sure, even like with the egg status and our zoning, it's something that I'm not sure how we can come together on, those types of things, because we've had property that is suburban residential district, it meets the 40 acres, it meets all of the egg criteria, it doesn't meet our zoning criteria for animal keeping. So, it's one of those things that we'll probably have to work with the equalization to find some common ground. I don't think everything will be perfect, but I think we could find some common ground, because I know that some of the concerns, that if they anchor it, it's going to be assessed essentially. Our concerns with anchoring has more to do with setbacks, easements, locations, being able to move it, things like that, so.
The carports, that, I've had people up here say, look, I can have that carport down in 2 hours because it took 2 hours to put up. And so then is that a permanent structure or is it a personal property? And these are, just be nice to, whatever way we decide, just so that we don't have to sit there and go through this debate. In the future, we're going to have other commission, we're going to have other planning commission. Just be nice to have something that we could go to that's black and white and definitive so that it doesn't have to be so subjective.
Okay.
Just food for thought.
Okay.
Brittany, right along the same line though, equalization uses your roof status as a guideline, like for patio versus a deck. However, if you pour a concrete apron around it, they include that in the square footage. If you just had a drain apron around that, that would be included in. So you could build 144 feet and end up a tax structure over there where you are less than 144 feet and not get a permit here. So
right.
there is some conflicts, like you say, that are going to exist, I think, versus how they see something versus the building side of it.
And we do have a section in our ordinance under, I believe it's 309, that, that certain soffits and things like that are not considered square footage for our purposes. So if you have an overhang and things like that. So when we look at setbacks, those soffits, those 18 to 24 inches are not considered, part of the setback. It's actually the building structure. So there are some exemptions in there. That isn't, all of these sections of the ordinance are, up for review. That may be a good place to put that. We did have one in front of you last meeting about the garage in the front yard. So it's under that, where you just have some kind of exceptions where you could do the carports, if there were, a single car, small carport. I mean, for the floodplain purposes, those are exempt structures. They do require a building permit, they don't require a floodplain permit. So there's some ways that we could address that either in the definitions or through that section under exemptions.
The 144, that's just the footprint. I know I've heard people go out there and build 2.5 story. Well, the footprint's 144 square feet, but we don't, there could be some relationship between the footprint and the height so that somebody doesn't go out there and try to have a 144 square foot footprint and build a 2.5 story shed.
With living quarters.
Food for thought.
All right, thank you.
Mini homes.
Further items from the membership? Hearing none, seeing none. Item 23, adjournment. I would entertain a motion.
I move adjournment. Move to adjourn. Sorry.
Second.
Motion and second. Further discussion? Seeing none, roll call vote.
Rich,
Aye.
Ron,
Aye.
Jim,
Aye.
Travis,
Aye.
Kathy,
Aye.
Charlie,
Aye.
Sandy.
Aye.
We're adjourned. Thanks, everyone.
Let's see.